Hi everyone, and welcome back to Introduction to Law. This time we're going to be looking at professional ethical behaviour. So this lecture focuses on the ethical standards that lawyers are expected to adhere to. We're also going to look at where these standards come from and how you can prepare to follow them. So how you can prepare to become ethical lawyers. So we'll divide this lecture into two sections. First, we'll look at professional ethics. These are the legal practice duties that lawyers have to follow. Then second, we'll talk a bit about being ethical. Why and how we as lawyers and as people can adhere to ethical standards. So professional ethics is up first. And when we talk about professional ethics, we're usually talking about a code or a set of rules that a profession, and in this case that's the legal profession, has put in place for all of the members of that profession to follow. And we might ask, well, why do we need legal ethics? Why do we need that code, that set of rules? Well, most professions, whether it's law or accounting, engineering too, think that a set of ethical and professional standards is important as a way of upholding the integrity and the reputation of that profession. And if we think about the perception of the legal profession in particular, there are some issues around its reputation. And this quote from the former Chief Justice of the US Supreme Court really sums up the problem nicely. He said, "In the past, when I've talked to audiences like this, I've often started off with a lawyer joke, a complete caricature of a lawyer who's been nasty, greedy, and unethical. But I've stopped this practice. I gradually realized that the lawyers in the audience didn't think the jokes were funny, and the non-lawyers didn't think they were jokes." So the legal profession gets a bad rap. It has a reputation for having an ethical deficit, a lack of ethics. So we might say that legal ethics are especially important in that sort of sphere of professional ethics. And they're especially important because they offer a way of countering that perception around lawyers' ethics or lack thereof. And these are the building blocks of legal ethics found in the Australian Solicitors' Conduct Rules. These are the key duties of solicitors in Australia, and they're contained in Rules 3 and 4. So Rule 3, our number one building block, is the paramount duty of solicitors to the court and to the administration of justice. That duty to the court and to justice prevails over all other duties. It's the number one duty of solicitors in Australia. That means it overrides other duties if there's a conflict between different duties. That's why we call it the paramount duty. And then Rule 4 goes on to talk about the other building blocks of legal ethics. These are not the paramount duty of solicitors, but the fundamental ethical duties of solicitors. So just underneath that paramount duty, we have the fundamental duties of solicitors, the duty to act in the best interests of clients, the duty to be honest and courteous, the duty to be competent, diligent and prompt, the duty to avoid compromises to integrity and professional independence, and the duty to comply with ethical and legal obligations. Now, it's important to realize at the outset that these fundamental duties, even though they're really important, obviously, hints in the name, they are just the starting point of what is expected of lawyers. And a good way of thinking about how much is expected of lawyers is to actually look at some other ethical duties, one of which is the duty to avoid conflicts of interest. Conflicts of interest arise because lawyers, as we've discovered already, have to act in the best interests of clients. What do you do, though, if you have two clients whose interests conflict with one another? What about if your interests conflict with your client's interests? So you have interests of your own, obviously. What happens if those are in conflict with your client's interests? a lawyer has to figure out what to do in these kinds of situations. And these are the rules. These are the rules that you have to follow from the Australian Solicitors' Conduct Rules. You must avoid conflicts between the duties owed to current and to former clients. You have to avoid conflicts between the duties you owe to current clients, but also the duties you owe to former clients. Rule 10 of the rules requires that if you hold confidential information on a former client that would be detrimental to their interests if you disclosed it to a future client, but that is also material to that future client's matter, then you can't take on that future client unless you obtain informed written consent from the former client and also set up what's called an information barrier. We can put it in these terms. Let's say you represented client A. Prospective client B comes along, but you realize that client B's legal problem would be helped by you sharing client A's confidential information. What the rule says is that there are going to be very strict standards in place before you can take on client B. Informed consent is going to be tricky to obtain here because it might require the clients to obtain independent legal advice unless they're what's called sophisticated clients. What we mean there is that they know a lot about the law and their legal profession. That's a sophisticated client. It's also difficult to do informed consent in this kind of situation because you have a duty of confidentiality to the clients. And that means that all of the necessary information to make a client informed might not be something you can actually provide because one of your other duties is preventing you from doing so. And then alongside this idea of informed consent before you can take on this client, we also have this requirement that you set up an information barrier. And again, this is a high standard. What you have to do is really quarantine your personnel in your firm from the information that might be otherwise compromised. You have to have processes in place to protect that information. You have to have systems and training to make sure that things don't go wrong. So it's a high standard before you can take on this other client. And then Rule 11 requires lawyers who are representing two or more clients whose interests are adverse, so they are against one another, such that there is or might be a conflict, to not act unless both clients are aware that the lawyer is also acting for the other client as well and have provided informed consent to the lawyer acting for both. So again, you've got this informed consent requirement, and that bar is high. On top of that, there's a continuing requirement placed on the lawyer to act in the best interests of both clients at the same time. So both clients' best interests, you have to act in both clients' best interests. Now, you'll see in Rule 11 this reference to adverse interests. And the reason that's there is because there are some situations where acting for multiple clients is less problematic and maybe even makes a lot of sense. If clients have common interests or a shared objective, then it might make sense for them to share a lawyer as well. Not all lawyering, and actually a lot of lawyering, a lot of what lawyers do, isn't about disputes. But outside of those kinds of situations, there are going to be significant barriers to taking on multiple clients in relation to the same matter. And that's for good reason, because it's going to be really hard for a lawyer to maintain confidentiality and act in the best interests of both parties, both clients. Rule 11.5 actually adds to this even more by requiring that if an actual conflict between the duties owed to clients arises, you must discontinue acting for both parties. You can continue to act for one party only if the duty of confidentiality of the other is not put at risk, and both parties have to give informed consent here as well. The idea here is that the bad thing we were trying to avoid happening with all these limits on conflicts has actually happened. You've taken on this client, but now a conflict has arisen and we need to do something about it. And you're going to have to drop at least one client because you can't act in the best interests of both. We told you in Rule 11 you had to act in the best interests of both clients. You can't do that anymore because there is this actual conflict. So you're going to have to drop at least one client. But if you drop one client, are you going to cause a detriment to the client who got dropped? Are you going to breach their confidentiality? Are you going to breach your ethical duties? Is there a risk that you might breach confidentiality in continuing to represent the other client, that one client who you've tried to keep on? It's going to be hard to do that, which means you're probably going to have to drop both clients. Then there's this possibility of conflicts between your interest and your client's interests. So you might have a financial interest, or you might have a personal interest in the client's legal matter. Rule 12 says that if there is a conflict or a potential conflict between the best interests of your client and your own interests, then subject to some exceptions around wills, around businesses and referrals, you should stop acting for that client. The duty of confidentiality. What this shows us is that sometimes there's a conflict between the duties that lawyers owe. So as well as a conflict of interests, you can actually have conflicts of duties. So you have to keep the affairs of your clients confidential. So Rule 10 of the Solicitor's Conduct Rules sets this out for former clients. Rule 11 sets this out for current clients. You have to keep their affairs confidential. But what do you do if you have confidential information about a former client that would be material to the interests of a prospective client? How can you act in the best interests of that future client while still maintaining the confidentiality of the former client? And it doesn't look like you can. Either you're going to breach one client's duty of confidentiality or another client's duty to act in the best interests. You're going to breach a duty to one of those two if you try and act for both. Those are only some of the ethical challenges that you'll face as a lawyer, and you need to start thinking about them now. But what I want to do for today is just move from looking at the rules to looking at why we have these rules and how we can use them as lawyers. So once upon a time, this was the position that lawyers held in relation to clients and legal problems. An advocate, by the sacred duty which he owes his client, knows in the discharge of that office but one person in the world, that client and no other. To save that client by all expedient means, to protect that client at all hazards and costs to all others, and among others to himself, is the highest and most unquestioned of his duties. He must not regard the alarm, the suffering, the torment, the destruction which he will bring upon any other. Nay, separating even the duties of a patriot from those of an advocate, and casting them, if need be, to the wind, he must go on reckless of the consequences if his fate should unhappily be to him involve his country in confusion for his client's protection. So on this 1820s understanding, the needs of the client are above all others, literally all others. The client is the most important person. But there are some problems with putting the client first. There are problems with this approach. Because whilst as a lawyer you're often working for a client, there are going to be lots of other stakeholders in the legal process. And as a lawyer, as a legal professional, you need to consider their interests too. Think about other lawyers. Think about other parties in a matter. You need to show civility, show courtesy, show consideration to them. There's also going to be other people who aren't parties but are still caught up in legal processes. We might think about witnesses here. If you're cross-examining a vulnerable witness and you don't show consideration of that witness's vulnerability, then that could have really serious consequences for the witness, for you, but also for your client, for your case. So we have these interests of other stakeholders, And we also have this idea of the interests of justice and the duty of the lawyer as a contributor to the justice system. If you lie or mislead the court, then what you're doing there is really subverting the justice process. And that is a process that you as a professional, as a lawyer, have signed up to maintain. So lawyers have to show candor to the court. They have to be honest and act with integrity so that they uphold and protect the justice system and the interests of justice. So the modern version of what a lawyer's obligations look like are less client-focused. They look a bit more like this. Every counsel has a duty to his client fearlessly to raise every issue, advance every argument, ask every question, however distasteful, which he thinks will help his client's case. But, as an officer of the court concerned in the administration of justice, he has an overriding duty to the court, to the standards of his profession, and to the public, which may and often does lead to a conflict with his client's wishes or what the client thinks are his personal interests. Counsel must not mislead the court. He must not lend himself to casting aspersions on the other party or witnesses for which there is no sufficient basis in the information in his possession. He must not withhold authorities or documents which may tell against his clients, but which the law or the standards of his profession require him to produce. So clients are still really important here, but there are lots of other obligations, and it's not that the client is number one. It's not that the client is most important here. The court, justice, is most important here. And that can make things a bit tricky when it comes to making ethical decisions as a lawyer, because the interests of the court and the interests of clients can actually pull you in different directions. You have a duty to both, and we know now that your duty to the court and justice is paramount, so it's going to override your duty to the client. But you still have to figure out at what point does this duty to justice start overriding your duty to the client? At what point do you stop being a zealous advocate and start being an officer of the court? At what point do you make that pivot from acting in your client's interests to acting in the interests of justice? Difficult dilemmas like that are why just knowing the rules, just knowing what the rules are, is not going to be enough to make you an ethical lawyer. We've known about this for some time. We've known that mere compliance with the rules will not make you an ethical person. And that's because legal ethics isn't just about rules. If it were just rules, we would end up with this idea of either spiritless compliance or skillful evasion. Lawyers have to follow the spirit of the rules, as well as the letter. They have to incorporate legal ethics into the way they think about their work. Otherwise, they're not going to be able to resolve ethical dilemmas. They're not going to be able to piece together those fundamental and paramount duties of a solicitor. They're not going to be able to reconcile the differences between Rule 3 of the Solicitor's Conduct Rules and Rule 4. To be an ethical lawyer means accepting the obligation that is on a legal professional to support the legal profession, and as a fundamental part of that professional role, to support justice, to uphold justice and the rule of law in complex, really difficult, and sometimes very pressurized circumstances. Lawyers play a key role in society, because when a citizen is going to be the subject of oppression or abuse of power by maybe a corporation or a person or a state, any of these things, when they're being oppressed by someone or something more powerful than them, the public needs an independent lawyer to ensure that justice is achieved. Legal ethics requires you to know the rules, but to also read those rules and integrate them into your practice in a way that reflects your obligation to justice. Legal ethics isn't easy, but there is support in place for lawyers to help them act ethically. The Queensland Law Society has developed this ethical deliberation model. And what that is a process that you can go through to solve ethical dilemmas. So you go through that process, you start by thinking, what's the ethical issue concerning you? You think about what options you can identify, what are the relevant interests in this situation, what guidance can you derive from sources of authority, go and read the code, go and read the rules. Are there any broader ethical considerations that you need to take into account? Maybe your duty to the court in terms of you upholding justice, being a legal professional. Who have you consulted with or discussed this issue with? What was their advice? Usually there's going to be a senior lawyer there to give you advice. In considering your options for action, what are the likely consequences? What have you decided is the best course of action in this case? And in summary, what are your reasons for deciding on this course of action? And the idea with this model is to get lawyers to stop and think. Lawyers often encounter ethical dilemmas. And if they go on a hunch, or they rush, or they panic into a decision without thinking, that can really have bad results. So what the Law Society has done here is provide a framework, a space in which you can just stop and think. You can review your decision, you can decide what you think you should do, and then you can figure out whether that really is the best option, using reasoned decision making, something we know that lawyers are really well trained for. So you can figure out if it's the best option. If it is the best option, why is it the best option? If it's not the best option, why is it not the best option? And what can you do to improve it? So this framework is really helpful in getting lawyers to think ethically, not just follow the rules. That wraps this lecture up. You might think at this point that legal ethics is something you don't really have to worry about. After all, you're not in practice yet, you're not practicing lawyers. But if you are looking to enter legal practice, while you're not yet subject to the solicitor's conduct rules, what you do pretty much from now on, the way you conduct yourself in legal education, is going to be a factor in your successful admission to the profession. So if you haven't already, I recommend you start being ethical now. Thanks for listening.